Okay, it's 9:01, so we're going to start. So good morning, everybody. I'm Susan Culhane with Nolte Insurance. You are seeing my fellow compliance and HR professionals on the screen, Carrie Nicholson. We have Abby Arbogast and Allison Hahn. Carrie and I are going to do the presentation today, and Abby and Allison are going to monitor our Q&A. So welcome to the lovely Michigan Earned Sick Time Act. And notice we put attention all Michigan employers because it truly affects all Michigan employers. Like I said, Susan, Carrie and I will be presenting. We do have our disclaimer down below that we are not attorneys, but we are seasoned, that's another word for old, HR people. But, and what we are presenting today could change. A lot of you might have been going to the Miller-Johnson webinars, the Varnum webinars, or Michigan Chamber. So if you've gone to anything else, you know that all of this still possibly could change. It could change before February. It could change after February. The good news is we just want everybody to be prepared. Don't ignore this. That's the one thing is my message today. You are going to get a homework assignment at the end of this, but please don't ignore it. Very popular topic. We ended up getting almost 300 people signed up for this webinar. So we're happy that we can provide this knowledge to everybody. And thank you so much for taking the time out of your day. We are only the messenger. Do not get mad at us for what we're presenting. Unfortunately, it is what it is in our world. As you know, when you're in HR and benefits, there's always something new that we have to comply with. We are also going to highly suggest that you sign up for information from the Labor and Economic Opportunity Commission for the state of Michigan. So it's Labor and Economic Opportunity. You can sign up for updates, but they are the responsible party for the ESTA law. So we'll talk a little bit more about that as we go through the presentation. We welcome your questions, and we thank everybody who, when they signed up, they asked a question, and we believe we are covering every single one of those questions. Abby and I went through them again yesterday, and we feel that everything that you asked us preliminary is in our presentation. So hopefully we will be answering those questions for you. But we do think that we will have time at the end of this webinar to do a Q&A as well. During the webinar, if you want to put a question in, please put it in the Q&A. Do not put it in the chat. I don't know if we could try to turn that off or not, but if you put it in the Q&A, then everything is recorded. And then when we send you this recording, you will be able to see those questions and answers as well. So you will be getting a copy of this presentation so you can share it to all your fellow team members at your organizations and any other HR professionals that might have questions as we go on. Well, here we are, earned sick time. You know what? We just have to do it. You know, we're busy, but this is another thing we get to add to our plates. Hopefully everybody's pretty much through open enrollment for 1/1. We know about 80% of the world renews their benefits this time of year. So this is your next thing that you get to tackle if you have not done so already. All right, how in the world did we get here? So what happened was this has been going back and forth in legislation and our courts since 2018. And I am not going to go into all the dirty details of this, but it's been going back and forth, back and forth, back and forth. And then you'll remember that in 2019, we landed on the Michigan Paid Medical Leave Act. So the PML is what we commonly call it for short. The PML was adopted March of 2019. We did a seminar on that. Many of you attended on that. So now what's happened is ESTA was enacted on July 2024. It's replacing the paid Michigan leave, and it's effective February 21st of 2025. No idea why that's the date. Have no clue. Really would figure that out because I think that's a Friday. So we have no idea why it's February 21st, but we just don't ask questions and we just keep doing what we have to do to comply. So here we are. Could it change? Yes, it absolutely could change. Keep watching for updates. We will send updates in our compliance newsletter if anything changes, because we're finding as we've been preparing for this webinar that more information has come out from Leo. And so we've had to update this webinar presentation. We were just updating it yesterday with some more information. So Leo has a really good FAQ out on the website. So sign up for Leo and you will be learning as we learn. Okay, who has to comply? Every single one of you on this webinar, obviously you're joining us for a reason. You are more than likely having to comply. So if you have one or more employees, you have to comply in the state of Michigan. And it includes all employers of every type, nonprofit, state, local government. The only exclusion here is USA government employees that reside in Michigan, railway workers and employers covered by the Railroad Unemployment Insurance Act. This is something new that they just came out with recently. Publicly elected officials, members of publicly appointed boards and commissions, and similar public office holders, unless the governing entity treats these individuals as employees. If you treat them as employees, then they also have ESTA benefits. But those are the only exclusions. So if you have a very small workforce, if you have part-time people, seasonal people, I often think of the small employers across the street from our office, everybody has to, is covered under ESTA. So we're going to get into all the details of this. One thing I do want to say, for those of you, might be a few of you who have joined, if you have unlimited PTO or an equivalent, you can leave the webinar because you're going to be covered. So there are a few organizations out there that have unlimited PTO or something equivalent where you just give time for any reason, whatever, and then you are going to be covering all the ESTA regulations that are out there. So don't know if there's anybody joining us today, but we would love for you to stay on, but you get to go if you do have some type of unlimited PTO or equivalent. Okay, Carrie and I are going to now go back and forth on the slides. So Carrie is up.
Thanks, Susan. And my first slide is going to be really depressing. The question, if I don't comply, can I be sued? Unfortunately, you can. It's really no different than if you're an employer that has to comply with ADA, that has to comply with FML. If you aren't complying and you get caught, there are going to be some pretty severe fines. Couple things to remember. I mean, we understand there's a lot of gray areas right now in this law. We're trying to figure it out. You're trying to figure it out. The attorneys don't have all the answers. So like anything, we need to educate ourselves and make a good faith effort to comply with the law as we understand it. Employees are going to be protected, right? This is just like FML. So there's job protection. You also cannot retaliate against an employee who uses ESTA. You may have an employee who only uses 1 hour of ESTA all year long. You may have another employee that uses all 72 hours of ESTA. Doesn't matter. You cannot treat one differently than the other. Massive liability exposure if you don't comply and you're reported and an investigation ensues and you're potentially fined. You may have to pay attorney fees. You're going to have to pay back pay, liquidation damages. The list goes on and on and on. There's a 3-year statutory limit, and then you're also required to keep any records of ESTA for that 3 years. Okay.
All right. So what employees are covered? We get this question all the time, our compliance team. So basically everyone is covered with those exclusions that I had before, but exempt and non-exempt, and any workers that are physically located in Michigan, regardless of their employer location. So that includes full-time, part-time, seasonal, remote in this state, temporary employees. So you're going to want to coordinate with your temp agencies on this to see who is responsible for it. Your contracts, you're going to want to read that. It's very similar to the FML and the PML. Make sure that you work with your temp agencies on how this is going to play out and who's responsible for this and who's responsible for the record keeping. Because like Carrie said, you do need to do some record keeping. And so you want to make sure, is it you, the employer, who has the temp agency employees, or the actual temp agency itself? Union employers, there was just recent news on union employees. And honestly, it depends on the wording in the CBA. There are two scenarios for the February 21st date. And this is what it says. If it currently includes sick time or sick leave benefits, or if it is silent as it relates to sick time or sick leave benefits. So that can be a little confusing in itself. Bottom line is, get your labor attorney involved. If anything to do with the CBA, we don't feel very comfortable getting into the nitty gritties of a CBA. And you obviously had labor help with that. And our advice is to get them involved too, especially with the recent wording in the ESTA regulations when it comes to any type of unionized employees. But for those of you, again, any small employer that has part-time people, they are covered. They're not covered under a lot of other things, but in this particular law with ESTA, they are covered. So you are going to have to definitely look at your policies and how you're going to move forward with this.
All right, how much time are we required to give? So if you are an employer with fewer than 10 employees working for compensation during a given week, you are considered a small employer. So that 10 employees that's listed is going to include your full-time employees, your part-time employees, and temporary employees. Also, when you're counting your employees to see, do you have 10 or more than 10? You are going to count all employees of the employer within the United States. Those are all counted for purposes of this act. So even if you have employees that are outside of the state of Michigan, when you are counting employees, you want to include those employees, even though they may be remote and they're working out of state. So if you are a small business, you are required to provide 40 paid hours and 32 unpaid hours. One thing to note, those employees are entitled to use paid hours before those unpaid hours. So as an employer, you can't say, hey, Susan, you have to use your unpaid hours first. You cannot do that. If you are an employer that hovers around 10 employees, you're a small business, 1 week you have 11, 1 week you have 9. There's kind of a lot of ifs and whens around that counting. So what we would recommend is that you reach out to your employment law attorney to kind of talk through that, or we can also kind of talk through what that looks like for you in terms of the counting.
That Leo FAQ has a really good scenario in it. We just didn't want to put it on our presentation because we probably would get sidetracked on it. But the FAQ has a great scenario that we all were educating ourselves on this week.
Yep. If you are an employer with 10 or more employees on payroll during any 20 or more calendar work weeks in the current or preceding calendar year, then you are required to provide up to 72 paid hours. So employees will accrue 1 hour for every 30 hours worked. The keyword there is worked. But they're not entitled to use more than 32 hours of earned sick time per year.
72.
Okay? Or I'm sorry, 72. Thank you.
Mm-hmm.
If you are salaried, you just assume this classification of employees are working 40 hours in a given week. If that doesn't apply to you, then you just use your standard, whatever that full-time hours is, 35 or whatever. But the law is presuming that 40 hours is your salary limit per week.
Okay, how is it earned? Well, that's a great question. We've been getting a lot of this, and it depends. It truly depends on what your policy looks like now. What are you doing now? Many of you have a front load PTO bank. And if you have a front load PTO bank that at least gives 72 hours, then you might be just fine. because ESTA can be included in this. I know way back 6 months ago when this came out, everybody's like, oh my gosh, do I have to have a separate bank of ESTA hours? Or can we include it in our one bucket of PTO? The great news is you can include it in your current bucket of PTO if you choose to do that, if you have that. So you can, if you have a front load PTO bank or an accrual PTO, that's fine. ESTA can be included in that. So you might already be compliant and don't have to do anything. You just have to make sure that you are compliant. So do you have an accrual system now? How do you define that accrual system? The thing is with this law is it has to be a 12-month period. So we have some people that are starting on it January 1st just to make it easy. They're just doing that as a calendar year. So you can do a calendar year, you can do a fiscal year, you can do it by their anniversary date. So whatever your policy is, you want to be consistent. Now we had a couple people say, well, what if can we treat one class of employees one way and another class of employees another way? Possibly, you absolutely can do that. Like Carrie had mentioned with the salary employees. So it's okay as long as your policy states this and it's understandable and you're communicating that to your employees. That's the big thing. Carrie mentioned this already. They must receive either by front load or accrual 1 hour of ESTA per 30 hours worked, no matter the work week. So for example, I work for a small employer. I work 20 hours one week, and then the next week I work 10 hours. So obviously that's over a 2-week period. And so I'm going to earn 1 hour of ESTA because I worked 30 hours. So you do have to have a payroll tracking system that you can, track this on. And if you need help with the tracking system, I was given one that is not tied to a payroll system. And just email one of us and we can share that system with you. Actually, one of our clients uses it right now for PTO tracking. They don't use their payroll system. So if you need that, let us know. We'll send you a quick email with the link. And it might be something that you want to consider. She said it's pretty, from a financial standpoint, it doesn't cost a lot of money. So just know that there are systems out there that can help you track this versus doing it on an Excel spreadsheet, which back in the day, we all know that's what we used to do to track things. But there obviously are large payroll systems should be getting us up to speed for Michigan employers to be able to track this in your payroll systems. But if you have not reached out to them yet, I certainly would do so. A lot of you are with like ADP, Paycor, Paylocity. I don't know, there's another one with P that I'm missing. But if you have an in-house payroll system or maybe an industry payroll system, I certainly would reach out to them and see if they have this covered for you. If not, you might want to buy some type of software to track it.
All right. When an employee uses ESTA, what is the required wage rate that an employer needs to pay? So the pay rate is going to be equal to the greater of either the employee's regular rate of pay or the Michigan minimum wage rate. Whichever is higher is what you will be required to pay. For any employee whose hourly rate varies depending on the work performed, that normal hourly wage is going to be that our average hourly wage in the pay period immediately prior to the pay period in which the employee is paid earned sick time. I know that sounds super confusing, but if that pay rate does vary, you are going to do a little bit of a look back to the previous pay period to see what that average was. And then that is what you are going to pay out for that particular week when the employee takes that ESTA. Fringe benefits are not included in the calculation of that regular rate of pay.
So another very popular question, do we have to allow carryover? And the answer is yes. They call it carry forward. So you must carry over or carry forward all unused time. For example, you give Susan, I'm eligible for 72 hours, but I only use 4 hours of my time. So I have a 68-hour balance of unused ESTA time. That time does carry over to my next 12-month period. So yes, any unused time needs to carry over. The same for small employers as well. For the next 12 months, you can still cap it at 72 hours of usage. So, and that's including the prior year carryover and the next 12-month accrual. So you can still cap it at 72. So again, if you have generous PTO policies, you might be completely fine if that's the way you do any type, you have that one bucket of PTO. If you have separate buckets, just make sure that you are including ESTA in one of those buckets, whatever it might be, but you have to allow that carryover. And, but again, you can cap it at this point in time for the 72 hours per year.
So you have an employee who submits their resignation. Are you required to pay out any of that earned ESTA? You are not, but there's just a couple things that you're going to want to consider. If you rehire that employee within 6 months, whatever balance they had accrued prior to leaving your organization, that is going to have to be reinstated. And they're going to be allowed to use that time right away. And then they're going to begin accruing additional ESTA time basically when they return. So there isn't that 90-day waiting period. They can begin accruing right away. You're just going to want to make sure, again, Susan and I can't hone in enough, you're going to need to look at several policies just to make sure that they're in line with how you're going to be administering this. So with the payout at termination, you're going to want to look at what you're doing currently and how you're going to need to revise your policy in order to basically state you're not going to pay out at termination. You can certainly do what you can pay out at termination, but you are not required to. So if you front load, so let's say, January 1, you're going to front load your employees with all of the ESTA time ahead, you may be able to recoup that leave if you have an employee that uses it all within, let's say the first few weeks. But one thing you have to be careful of is you want to determine how much or that amount that would have been accrued as the date of separation. And then recoup that value in that final paycheck, but you need to make sure that that does not lower the employee's pay rate, base rate, below that minimum wage level. So it's kind of no different than, if you have safety boots or you have uniforms and an employee leaves your organization, there's some employers that want to recoup the cost of those materials and equipment, but you can't go lower than minimum wage when you provide that employee's final paycheck. So it's no different than what you may be doing currently.
And the key is with this, anytime you're taking money out of paycheck, you have to have written notice in a voluntary agreement of this deduction. So you want to make sure that the employee understands, that if they utilize this and then they leave, that they know that this will be happening. So again, document, document, document. You can't hear that enough in our world. Okay. So what can ESTA time be used for? So there's two categories. You have the employee, but then you also have a family member. And we're going to get into what a family member means in just a minute. But it can be used for mental or physical illness or a health condition of an employee or a family member, a medical diagnosis, care or treatment, preventative care. And one of the main reasons behind this law was the victim of domestic violence or sexual assault, anything to do with medical care, counseling, relocation, the participation in civil or criminal proceedings, and the exposure to a communicable disease. All of those are reasons. In addition to if the child, a meeting at a child's school or place of care related to the child's health or disability or the effects of a domestic violence or sexual assault situation, and a public health emergency closing. So we all went through this whole COVID thing. That could be part of ESTA in the future. Hopefully we never have to do anything like that ever again. But there are a lot of reasons people can use ESTA. And again, it's for themselves or a family member. So make sure you educate not only your wonderful HR team, but we are going to highly encourage that you do training for your supervisors and managers as well. As some of you know, we do supervisor training on, I call it the HR Bermuda Triangle. You can call it whatever you want, where you cover FML, the Pregnancy Workers Fairness Act, ADA, COBRA, etc. We will be adding ESTA to that. So if you want us to help you with the training for your supervisors and managers, we will do that. But please make sure that they understand all the reasons why somebody can take ESTA. And they're going to rely on you to educate them for when an employee can be out. All right, Kara, tell them who it's for.
All right. Pretty much everybody, you guys. There are very, very few exceptions. Again, go to the Leo Q&A. It will give you a list. And when you look through that list, you'll be like, yep, there's very few exceptions. Pretty much anybody. So individuals related by blood or who closely associate with that employee or the equivalent of a family relationship. And the above statement pretty much explains it. Domestic partners and their children are covered. Committed relationships similar to common law, those relationships are covered. Those employees are covered. So again, it's essentially everybody. And I would caution you to ask a lot of questions of the employee when it comes to these relationships. I would just tread very lightly when you try to get information and you're trying to figure out what relationship they may be. I would just be cautious.
As we always say, err on the side of the employee. I know we don't like to hear that, and I know it's difficult for people who are rule followers, and I get it. But there's going to need to be some gray here. And I think, that employers are feeling, oh my gosh, I have the handcuffs on me again. And absolutely, you might. But educate yourselves, educate your supervisors and managers. But like Kara said, I think you have to be very careful about retaliating and asking so many questions when it comes to this. I just had a conversation with one of my clients yesterday about a call-in situation. And, I expressed to her, and we talked about it with our team here, that if an employee is going to take advantage of ESTA, they're probably taking advantage of everything else as well. And in the long run, there's going to be a performance issue. Those of us who have been in HR long enough just know that that's probably what's going to happen. Are they going to burn through 72 hours of ESTA? They might. They absolutely might. But they're more than likely there's performance issues too. So those are the things that you want to document as well. Not only this, but also document those performance issues. And just that way, the employee is going to understand that you are running a tight ship as much as you possibly can. But don't go crazy trying to, figure out all these relationships. It's going to be a tough one for all of us, to be honest. Okay. Can we ask for a doctor's note? Maybe. But it may come at a cost to you, honestly. So if more than 3 consecutive days, you can ask for reasonable documentation. So reasonable is the word that is used. Don't withhold ESTA leave due to not receiving that documentation. That could be looked at as a retaliation. Do not give them attendance points right away. Again, err on the side of caution and the benefit to the employee. There might be very valid reasons why they cannot give you reasonable documentation ahead of time or right away. So you just, again, we have to practice patience, and that's one thing that I am not necessarily known for, but all of us need to practice this as much as we possibly can. And documentation must state it meets ESTA requirements, and it does not need to give details of illness or domestic violence. So what does that mean? That means that if somebody is seeking any type of professional help, whether it's for physical or mental, that a doctor, all the doctor needs to write on there is that it meets ESTA requirements. That's it. They don't have to tell you what it's for, why they're there. I mean, again, it could be a domestic violence situation. It could be some type of sexual abuse situation, whether it's a physical or mental. As long as it says it meets the ESTA requirements, as an employer, that's all that you can do. And if you require documentation, this is the big one. If you require it, the employer is responsible for all out-of-pocket costs associated with that healthcare provider. So Carrie comes to me because I'm off, and she said, Susan, I need to know why you've been off these last 5 days. You need to give me some documentation because it's been over 3. So she has the right to ask me for that. And I'm going to look at her and say, well, you know, I've been seeing a therapist. And she's like, okay, I need a note. I need a note from the therapist. And so if I have an HSA, that therapist cost could be $140 for me. If I have to physically go there and get a note from her, it potentially could. Or some doctors' offices are charging documentation now. So if that's the case, I can come back to Carrie, my HR person, and say, here's my out-of-pocket cost for that documentation that you've asked me for. So we just want to make sure that you all know that the employer at this point in time is responsible for the out-of-pocket costs associated with a healthcare provider. It might change in the future, but as it reads today, that's what they're stating.
All right, can we ask the employee to let us know well in advance of the ESTA leave? Yes, but I feel like we're saying but all the time, Susan. Maybe but, yes, but. If foreseeable, it cannot exceed the 7 days prior to the ESTA date. So we can ask for advance notice, but not to exceed that 7 days prior. If not foreseeable, as soon as practical or practicable. So that's kind of a gray area, right? What does that mean? Well, deciding what is practical is really dependent on the unique situation and facts of that leave request, right? So again, with a lot of things in HR, we can't, it's not black and white. Every situation could be different. And so I think we have to treat each situation differently, get the facts, get the understanding before we basically come to a conclusion. And always we want to review those policies. So you may have a no call, no show policy in place, the disciplinary action policies. You're going to need to revisit those because just because somebody is absent one day and using ESTA, and we may not know until the middle of the day that they're using ESTA, you can't look at that as a no call, no show. So just be very cautious about your policies and make sure that they're written consistent with ESTA.
Yeah, don't jump to disciplinary right away, like the attendance points or whatever you might use to document these types of things. You might have somebody down at Bronson Hospital that was in an automobile accident that's in a coma, and they have no family members to let you know that they're not coming to work today. So it's one of those things that you have to do research before you do any type of disciplinary event whatsoever, because we have to be a little bit more lax now, especially with the ESTA, the way it reads today. FML, some similar language in it as well. Okay, so here's a few nuggets that we want to I know it's probably on people's minds how this can work. So a few nuggets that we want you to know about is new hires. You can wait until the 90th calendar date after their start date before they can begin using their time. However, they do accrue it from day one. So as soon as you hire them, they start accruing it 1 hour every 30 hours worked. They start accruing it unless you decide to front load them. But you can have them wait that until that 90th calendar day, especially with people with high turnover. This might be something that you want to do. We totally get that. So you can be generous and give more than 72 hours because, again, if you decide to put this under one bucket in your PTO policy might be much more generous than just the 72 hours. And again, it can be part of that PTO bucket. So if you give more than 72 hours, that's great. That's just the minimum. And so as far as what you need to do, ESTA can be used in 1 hour increments or your payroll system smallest increment, whichever is smaller. We get this question a lot. How do I track this? How do I need, how am I going to pay these people out? But it really depends on how your payroll system, some of them go all the way down to like 15 minutes or even less. So it has to be the smallest increment that your payroll system will allow. Again, but 1 hour increments might be the easiest way to do it, depending on, again, whatever your payroll system is allowing you to do. Employers can decide if hours accrue while someone is on vacation or holidays. That is completely up to you. If you do it today, you might want to continue doing it in the future. You don't have to do it on vacation or holidays, but you can decide that if I'm off for one day, let's say I take Monday off and as vacation or a holiday, am I going to include that in my 40 hours, which you absolutely can, or you don't have to. It depends on how advanced or how detailed you want to get on this. Do not assess attendant points for people utilizing ESTA. This may be viewed as retaliation. So it goes again to the education piece. Also want to just mention that you can run this concurrently with FML. But the ESTA provisions apply first, then FML. So any type of notices, any type of having to wait for documentation, all of that. ESTA is a little bit more generous when it comes to those types of things. But while they're running concurrently, ESTA and FML, the ESTA provisions are going to apply first. And then once ESTA is off the books, then FML would apply. So just make sure that if you are an FML employer, that you, again, have that documented.
All right, so what are your next steps as an employer? Well, first and foremost, you want to look at your policy and see if it's compliant. There's a lot of generous employers out there. You may offer unlimited PTO. You're probably A-okay. With a couple of tweaks, you're probably fine. If you're front loading and you front load well more than 72 hours, you're probably going to be okay too. So you just need to take a look at your policy to see if you are compliant. Then you want to determine how you are going to provide the 72 hours. Are you going to front load it? Or is it going to be on the accrual? Again, for the front load, you just want to determine your 12-month period. You could use calendar year, you could use your fiscal year, you could use anniversary year of the employee, so you can determine what that 12-month period is. Susan said earlier, there's some employers just for ease of administration, they're just deciding to start this on January 1st. You are more than welcome to do that. But you do have to do something by February 21st. Okay, that's the deadline. Make sure your payroll system's set up properly. So if you're using ADP, Paycor, Paylocity, there's several others out there, pick up the phone and call them and ask them. And I'm hoping they're certainly well aware of this and that they're doing the behind the scenes work to make sure that they're compliant. But you probably want to do some of that now in preparation for February 21st. Put your new labor posters up. So we've provided a link here. You click on that link. And it'll take you right out to the posters. You can print those off and post it along with your other employment law posters that you have set up in your organizations. And then the confidentiality piece. This is so important. If you are an employer who, is more than 50 employees and you're following FML, then you fully understand the level of confidentiality. We have to be very careful of the questions that we're asking employees. We don't want too much information. And Susan mentioned earlier, I think you're going to want to also look at training your frontline leadership, because they're going to probably be interacting more with your employee group than you are. And you want to make sure that they understand kind of what their boundaries are in terms of asking employees a lot of questions around protected health information.
Okay, to continue your homework assignment, review any policy relating to attendance. That's something that you for sure want to look at, because we want to make sure you've got proper wording in there. And again, we can't stress enough that if you have a relationship with a employment law attorney, that you get them involved. I know Miller Canfield, you could buy a toolkit on this. That had a sample policy in it. Now, granted, it was like, I feel like 10 pages long, that you can certainly, they're lawyers, you can certainly, but pare that down a little bit, but make sure that all of your policies are up to date. Retain records for not less than 3 years because the state can request them. There is no case law on this yet because it's a brand new regulation that we have to deal with. So always maintain your records, have them ready. Obviously, we all know there's going to be case law on this at some point or the other. Watch for new legislation on this from LEO, Labor and Economic Opportunity. That is the commission that is in charge of ESTA. And so we talked about it. Go out there and sign up for their any type of notices that you can get. I'm sure you can do it by email, but they have a very, very good Q&A. And that's one thing that we look at probably weekly. So you have to provide written notice to employees and new hires at the time of hire. You have to tell them the amount of ESTA that is provided, how ESTA is calculated, how it can be used, that you cannot retaliate against them, that they have the right to file civil action and file a complaint with the state, and you have to provide them how to file. This is the link right there. So all of this can be put into a handbook policy. If you have a handbook already, then you would just have an ESTA policy that would cover all of this. A lot of people ask sometimes, well, do I have to have them sign off on that? That's truly up to you. It depends on, do you have them sign off on other policies? Some of you have been admin systems that when a new hire comes on, they have to sign off that they received the handbook or certain policies. You can include that in there. If you have a benefit guide or any of those types of things, you can list that on your new hire onboarding. But as long as they get it somehow, that's the most important thing. All right, we have concluded our presentation, and now I'm going to open it up to Abby and Allison to see if there's any Q&As that we need to, that are some good ones that maybe you want to share or we want to have for some discussion points for the last 15 minutes.
Yeah, there's a lot of questions that came in, a lot of conversations going on in the Q&A. So great job, everybody. I think Alice and I are trying to answer as many as we can as they're coming through. But here's a couple just to get started. So the first one here is, could you give your opinion on how the ESTA may impact employers with policies that if you call off before or after a holiday and then don't receive holiday pay?
That's a really good question. And I think it's probably just like anything else that you have to, that you would put that in a policy, how that would be, how that holiday pay would be affected. Again, I always err on the side of being more generous so you don't have an issue. But have your policy written, check with your employment attorney about how you want to do that moving forward. I certainly would not deny the holiday pay until you have valid reason to do so. I'm always one that of the opinion, just pay them the holiday pay. It's the
Yeah.
easiest way to do it. So that is my opinion, is to pay holiday pay. I don't think it's worth getting into an argument over it. Again, if people are going to abuse ESTA, more than likely they're not performing well in other areas of their job. So I think you have to be careful. I think there's a fine line there, but I'm of the opinion, be more generous and give them the holiday pay.
Okay, so this one is very interesting. This is the question. We have 3 EINs and are considered an umbrella company. Some of our EINs are under 10 employees. Because we have over 10 employees throughout the 3 EINs, do we fall under the 42 hours period or the 72 hours paid? Sorry. And I'm not sure if everybody knows what an EIN is, but I'm assuming that this means that there are different locations with 10 or fewer employees, but they have more than 10 total at different locations.
If they have more than 10, I'm going to err on the side that it's 72 hours of paid leave. I think I'd have to learn more detail about it and how you measure those. And again, that FAQ gets into how to measure employees. So I would look at that on the Leo site. But if they reside in Michigan and if the employer is in Michigan, then cumulatively all together, they are employees, then I think they're at the 72.
Mm-hmm.
That's my opinion. Care, I don't know.
Yeah, I would agree based on what we know.
Yeah. Again, erring on the side of being more generous is always going to be better than erring on the other side of it. What else do we have?
Okay, so the next one here. Okay, sorry. If you front load 80 hours of PTO time, how do you prove that they used ESTA time? It seems to me if they use 40 hours of vacation and they get ill later, that they need 72 hours of ESTA that will have to pay more than their PTO hours.
This is a fantastic scenario. And this is where if you put everything in one bucket, you really don't have to worry how they're using that bucket. Paid time off is paid time off. If they choose to use that whole 80 hours for vacation and then get sick later on in the year, that's not, I don't want to say that's not your problem, but you abided by the law by giving them 72 hours. You do not have to go above and beyond that 80 that you've already given them. That's 80 hours they get to use for ESTA, for vacation, for whatever they want to use it for, and you don't have to ask for documentation. So PTO is kind of, a lot of people went to PTO years ago, all under one bucket, and because we didn't want to worry about what people were using it for. Same with ESTA. Don't overcomplicate it. If you get PTO and they use it all for vacation and run out for sick later on in the year, it's no different than today, really.
Mm-hmm.
So that's the
and if they use all of that time, right, and they have nothing else left and they're sick, I mean, at that point in time, you can follow your normal attendance policy and you can actually discipline. So when they use it all, it's grounds for disciplinary action if you go that route.
And that's part of the education process with your employees. I think they need to know. They're going to start hearing about ESTA. They're going to start hearing about it. And so it's up to you as the employer to educate. All right, we give this bucket of time to you. That bucket of time includes ESTA, just like a lot of people included the paid Michigan leave in that bucket. Very similar situation. So as long as you're giving them at least the 72 hours, if you're over 10 employees, then you should be fine. The law clearly states that you can front load it and that you can put it in a bucket, one bucket. So you should be fine. If they end up not having enough time, then you could work out a situation where they would have unpaid leave. and categorize it as unpaid leave. So we were happy to see that you could put it under one bucket. When this first came out, we were like, oh no, do you have to have a separate bucket just for ESTA? But when you look at the regs, you're okay to have the one bucket of PTO and include it in that bucket. That's a great question.
Yeah.
Anything else?
Okay, so we have some desire for clarification on advance notice and what that means for as soon as practicable. Due to the nature of like childcare business, they, if they don't meet their child to teacher ratio, then they have to send children home. So would that fall, like, what does that mean for advance notice requirements and practicability?
That's a great question.
It is a good
But I'm
question.
not sure if
I
have the
agree.
answer to.
That's why I
Yeah,
thought
the
I would- we could bring it for
legislation
discussion.
doesn't get specific as to what is considered practical.
Yeah, it doesn't. That might be, I mean, to me, if it closes, let's say to a public emergency, then it is what it is. I mean, there's nothing we can do there. So I'm going to go back to saying this is, you have to have open communication with your employees and welcome open communication with your employees. It's that respect back and forth, that, there just has to be communication, and you have to all figure this out together. What you don't want to do, this I know for sure, you don't want to do is jump to conclusions and automatically give them attendance points or whatever your system might be. Don't do that. Have a conversation first to see if they meet the requirements. And if they meet the requirements, then move on. Because it's going to be the easiest route, the path of least resistance in this case.
Yeah.
Okay, this next question is some clarification on the accruals. So very fun conversation. There's two parts of this question. So the first is 1 hour of accrual for every 30 hours worked on a standard 40-hour work week. Keep up with me. 52 weeks of a year that only accrues 69.33 hours, not 72. Even 53 weeks only accrues 70.66 hours. How are employers supposed to set this up within their systems? And then the second piece to this is that, yes, confirming that the accrual thing is very confusing. They have part-time staff who will only work 300 hours in 12 months. I assume we still have to provide the 72 hours because we have more than 10 employees.
Correct. That answer to question B is
the part-time.
Yes, absolutely, part-time is included. So also remember, overtime is included in this as well. So that's where if somebody works overtime, they might accrue those hours sooner than working just that straight 40 hours. And I'm telling you, again, we try to get into the legislation brain of these people who are creating these regulations for us. I can guarantee you they did not ask payroll people anything before they made this law. So now we all have to figure this out. And that is definitely a question. I've been at some of Miller Johnson seminars and webinars, and that question is brought up. The answer is, the big thing is 1 hour of ESTA for every 30 hours worked. However they work those 30 hours, if they work, if I work 60 hours in 1 week, I'm going to get 2 hours of ESTA. So you just have to have your payroll system set up for that 30 hours. I'm not sure I answered that question, but I know it can get confusing when you do the straight 40 hours.
Right. So, and I think the key is it's up to 72 hours. So it's an accrual based on 1 hour per 30 hours.
Yep.
So if you're doing accrual, you may not, in many cases, you may not get to the 72.
They may not, especially part-time employees, for sure. Yes. Yep. That's exactly right. And that's the max you need to give, unless you're more generous, which is fine. You can be more generous.
Okay, here's one that I have. So the question is, if we pay out of pocket costs for the documentation, wouldn't this also be for FML? Requirement of 3 days needed documentation. If they need FMLA paperwork, then the employer would not have to pay.
Okay, so this again is where there's a lot of gray. Sometimes you're right, you're going to run these concurrently. ESTA provisions are a little bit more lenient than FML provisions are. And so you might just want to make a standard practice that we're going to pay for everything out of pocket. I know you won't, and that was being very over exaggeration. But you want to look at those types of things. You absolutely want to look at it, because ESTA does say that if you require documentation, that the employer needs to pay the out of pocket cost. Now, obviously that could include FML because they could run it concurrently. Yes. These are great questions.
All right. I'm trying to find one here. I read that if we allow vacation to be used in whole or half-day increments, that we can restrict ESTA hours to the same requirement. Is that true?
I don't think so.
Vacation used.
I'm going to say it has to be what your payroll system allows, is my understanding.
The least, isn't it the least increment
Yes.
of time that your payroll
Yes.
system allows? Yeah.
Yeah. I would review that with your labor law attorney or your employment attorney, but my understanding is that you cannot limit it to 4 hours or 8 hours.
Yep.
And until we get more clarifications from Leo, I think err on the side of generosity. Anything else, Abby or Allison? Got 2 minutes left.
I have one that says, can we let employees use their 72 hours for anything rather than deep diving into what they are using the time for?
You absolutely can do that. That's kind of like that's the beauty of a PTO type bank.
Yeah.
Is to allow them to use it for whatever. And then you don't even have to get into the documentation piece. They use it for vacation. They use it for ESTA. They use it for doctor's appointments or whatever. They're taking their child to on a field trip. So that's the beauty of PTO, is you don't have to get into the documentation piece of it. But I understand that doesn't work in every organization. I truly understand that. So just make sure your policies are written the way that you want this to, well, not the way that you want, because some people nobody wants this. So have your policies written where it's easy for the employees to understand. I've looked at so many attendance policies and PTO policies in the past, and I've been doing this for a long time. And I read these and go, I don't even understand what these say. So if I don't understand them, how is your average employee going to understand this? So the simpler you can make this, the better it will be for everybody. All right. Well, I think we should wrap up. The Q&As will also be listed in our link that we send you with this presentation. Obviously, our team is available. I would highly suggest you go out and look at the FAQ on Leo, because that answers a lot of the questions we all have been asking these past few months. Share this presentation with your team if you want, or if you want us to do any type of supervisor or manager training in the future, we are happy to do that. But thank you so much for spending your time with us this morning. We really appreciate it. And everybody have a wonderful and safe holiday season. So take care, everybody.
Thank you, everyone. Take care.
Bye.